Here we go. Here's the big story. From WCCO, CBS Minnesota, Derek Chauvin's attorney files motion for new trial. They report, attorney Eric Nelson has filed a motion for a new trial for former Minneapolis police officer Derek Chauvin in the death of George Floyd. Nelson filed the motion on the grounds of juror misconduct and that the court abused its discretion for failing to agree to the defense's request for a change of venue and sequestering the jury. I'm going to stop right there. It's actually substantially more comprehensive than that. This kind of feels like local outlets are trying to downplay the defense, as they keep doing. It's particularly annoying. So the filing comes in the midst of a controversy surrounding a photo of juror Brandon Mitchell at the March on Washington last August, which included speeches from George Floyd's family members. He is seen wearing a t-shirt that says, "Get your knee off our necks." In his juror questionnaire, Mitchell wrote that he had not attended any protest over police brutality. Mitchell told WCCO Monday that he was at the march in support of ramping up voter turnout. That doesn't matter. They didn't ask, did you go to a police brutality protest for another reason? They said, did you? And he said, no. He lied. Here's where it gets crazy. This dude is interviewed in a podcast called like Get Up Erica, I think it is. Get Up Mornings with Erica or something, where he's asked about jury duty. He says, if you want to affect change, I'm paraphrasing, you got to get on these juries to affect change. I mean, right then and right there, you see his motivation. He wanted to get on the jury. He lied to get on the jury because he wanted a guilty verdict that is not impartiality. But let me pull up the actual file and then we'll get into this. Check this out. So this is the actual legal filing. Notice of a motion and motion. They say, to the above named court, the Honorable Peter A. Cahill, Judge of Hennepin County District Court, and Matthew G. Frank, Assistant Minnesota Attorney General. Maybe the Attorney General will take this and go, gee, these are great arguments. I'm going to have a new trial for Chauvin. But I really doubt that Judge Cahill receiving this is going to do anything other than no, ignore it. So this is the defendant's notice of motions and post-verdict motions. They say they're filing a motion for an order granting a new trial, saying on the following grounds: the interest of justice, abuse of discretion, abuse of discretion that deprived the defendant of a fair trial, prosecutorial and jury misconduct, errors of law at trial, and a verdict that is contrary to law. The specific basis for this motion include but are not limited to. They say they didn't change the venue. They abused its discretion when denied the motion for a new trial on the grounds of publicity during the proceedings, threatened the fairness of the trial. Say the court failed to sequester the jury. The state committed pervasive prejudicial prosecutorial misconduct, which deprived Chauvin of his constitutional rights to due process in a fair trial, including but not limited to disparaging the defense, improper vouching, and failing to adequately prepare its witnesses. The court abused its discretion and violated Chauvin's rights under the Confrontation Clause when it failed to order Maurice Hall to testify, or in the alternative, to admit into evidence Mr. Hall's statements to law enforcement regarding his interactions with Floyd. Maurice Lester Hall was, according to Floyd's girlfriend, their drug dealer who was there with George Floyd. He pleaded the fifth, and there were questions from the defense as to why the prosecution would not grant him immunity and subpoena him to testify. Maybe some people assume it's because they want to charge this man later with the murder of George Floyd, or at least have that open as an option. But they could have said, you'll be immune from prosecution. Now testify as to what happened. They didn't do it. We got more. The court abused its discretion when it submitted instructions to the jury that failed to accurately reflect the law with respect to second-degree unintentional murder, third-degree murder, and authorized use of force. They say it violated Mr. Chauvin's rights when it permitted the state to present cumulative evidence with respect to use of force. That's interesting. I guess they're saying there should have been one expert saying, here's what the policy is, and be done with it. But they brought in multiple people saying just different things. The court abused its discretion in violation of Chauvin's rights when it ordered the state to lead a witness on direct examination. They say they also failed. So here's, I think this is in the motion. It failed to order that a record be made of the numerous sidebars that occurred during trial. And they say, J, the cumulative effect of multiple errors in these proceedings deprived Mr. Chauvin of a fair trial in violation of his constitutional rights. And then it finally gets to 2, because it was 1, A, B, C, D, you get it. 2, it says an order for a hearing to impeach the verdict pursuant to Minnesota R. Crim P 26.03, subdivision 206, and Schwartz v. Minneapolis Suburban Bus Co. On the grounds the jury committed misconduct, felt threatened or intimidated, felt race-based pressure during proceedings and or failed to adhere to instructions during deliberations in violation of Chauvin's constitutional right to due process and a fair trial. They say a motion for an order granting the defense additional time to thoroughly brief the above issues and any other relief deemed fair and equitable by the court. The motion is based upon the files and records in the case, yada, you get the point. And I really, really doubt this will go anywhere. But okay, now that we've gotten through all that, the trial wasn't fair, in my opinion. I don't know what you guys think, and I don't think there's going to be a new trial. But if there is, I don't know, how many buildings do you think they'll burn down this time?
Oh, gosh.
7.
That's the problem.
7.
That's the problem. 7. That's a great number.
A good solid number, 7.
Can't go wrong.
I think it's going to be more than that.
It's going to be at least 7.
Yeah, so they can't put this appeal in until after sentencing, right? Isn't that how this works?
This is a motion for a new trial.
Okay.
Yeah, I'm not sure how it works. I'm not a lawyer. I don't think this is an appeal. I think they're outright saying the court is out of order. Y'all need to give us a new trial. I really doubt the judge.
I doubt they're going to do that.
The judge already refused to do all of these things listed.
Right.
Like, we're going to have a trial right here in the city while the city's on fire. I'm sure the jurors will be fine about that.
Dude,
Yeah.
the guy had a Black Lives Matter shirt on at a protest. The juror who says to affect change, you got to weasel your way. He didn't say weasel.
Gotta get on these juries.
You don't get on a jury to affect change. You get on a jury to be a neutral arbiter of the law.
I actually agree with what he said. It's not about like for activism purposes. You know, maybe I disagree with the spirit of what he said. But the idea is if you want positive change in your community, you've got to be active in civics. You got to get on juries.
Yeah.
And when someone's accused of, like, I'll tell you this: if I was on a jury, and this will disqualify me from all future juries related to gun laws. If I was on a jury and they were like, this young man, Chicago inner city young black man has a handgun, and they're like, he's being charged with felony possession, I'd be like, I vote to nullify, jury nullification. That means you can, as a juror, choose to say he's not guilty, even if they instruct you. Like, they give you instructions where they say, if the law says you can't have a gun, and you believe he had a gun, then he's guilty. You can go, nah, I don't think it should be illegal to have a gun. So if it were me on a jury, I'd be like, nullify. You got to have a pretty damn good case to get beyond a reasonable doubt.
What do they do in those cases if you're like the lone juror that
mistrial?
So how long will they deliberate until they're like, we can't, it's a mistrial?
I mean, I don't know. I'm not a lawyer. I'd imagine it could be theoretically quick. If you were just sitting there with your feet up, you're like, I will never change my mind. Like, and then just plug your ears and go, nah. They might come out and be like, he's not going to budge. We're not unanimous. There's no, not unanimous.
So I wonder if they could charge this juror separately. Do you know what I mean?
They should. I think he should get perjury or something.
They should. But I mean, that wouldn't affect Chauvin in any way, so.
No, I mean, if they did, it would probably force a new trial. But they're not going to do it because the judicial system is, look, man, the crazy terrorists got their way. They went around smashing up buildings, setting fires, breaking windows, and cowardly Cahill, that's what I call him, he's the judge, just gave in and didn't treat this appropriately. He could have just said, look, we can't do the trial here. Any reasonable person would suggest as much. And he said no. He kept the trial in a place that's just absolutely ridiculous.
And then he made those comments about Maxine Waters. Remember?
Right.
He said, oh, this could end up in a, right? And then he keeps going forward. And you're just like, dude, what?
He was, my opinion, he was scared that if he said, okay, we're going to move venue, he'd get the pig's head at his house.
Yeah.
You heard about the juror, I'm sorry, the witness who got a pig's head at his house.
Yeah.
Oh. I heard the metaphor. I didn't know that actually happened during the Chauvin case.
Yes, one of the witnesses for the defense, his old house had a pig's head and blood smeared on it.
This is like mafia tactics.
Dude, it's terrorism. And guess what? Hey, it worked. These people got what they wanted.
Yeah.
Honestly, a new trial, if you truly believe he's guilty, I can't imagine you would have a problem with another trial.
You know what, man? We've already heard from these leftists who are saying, why do we even need a trial? We watched it on video. It's like, dude, because you have no idea. Like, man, imagine how stupid that statement is. Because we've heard it from many leftists saying, we all saw it on video. Imagine I walk up to you, Ian, and I punch you in the face as hard as I can, right? And then you defend yourself, but when the police arrive, they say you hitting me, and you get arrested for it.
That's like old school bully tactics.
Yep. So you can't just look at a video and say that, like, that's definitive proof of something.
Well, point in case, remember the Capitol Hill insurrection with Brian Sicknick. Remember, it came out that he was hit with the fire extinguisher and that killed him. And then it came out later it was natural causes.
Right.
And so everyone said, well, we saw the video. He got hit in the head. And then people were like, that's how he died. And then they came back and said, no, he had 2 strokes.
You know, when I started doing all the live streaming stuff, I had journalists telling me, like, now that we have this, like, live on the ground reporting, you can't fake news anymore. And I was like, what do you mean? It's easier than ever to fake news. Live streaming has made it easier to fake news.
Yeah.
Because people believe they're watching raw, real footage. It's so easy to just, lying is always easy, and abusing people's trust is always easy. It's scary. It's unfortunate. And we can see how the corporate press takes advantage of that. So you can't just look at a video. And most of us did. I think almost all of us did. We watched that video and we were angry about it. And then all of a sudden more information came out. And I think a lot of us got embarrassed that we jumped the gun on that one.
I thought Chauvin was so guilty and villainous. And then I saw the second video of what's his name? Why can I not remember this guy's name
Floyd?
sometimes? Yeah, George Floyd.
Yeah.
Just like kicking and whining about how he can't breathe before they even like
He's
apprehended.
in the car.
Yeah,
So-
like pushing himself out of the cop car and then he's on drugs. I'm like, what? And he's on fentanyl and meth and like, oh
Yeah.
my god. But that first video was it was still burned in my brain. I was just able to kind of compartmentalize it, and I don't know if many people can do that.
Yeah.
Well,
Yeah. Well, I thought it was weird. The defense attorney kept saying, like in his closing statement, he said, any reasonable cop would have done this. Any reasonable cop would have done that. And I said, well, I don't know if any reasonable cop would have knelt on him for that long as he was already subdued. And I thought, to me, that was a hard sell, because he was already in handcuffs. He wasn't really moving around. I thought any reasonable cop I know would have stood up.
except I think it was the prosecution's own witness who testified they did the same thing.
Really?
That's why I'm like watching this trial and I'm just confused as to how this verdict came about, other than the jury walked in the room. As soon as the door closed, one guy goes, I don't want anyone burning my house down. Can we just say guilty? We all agree guilty? Okay. But we can't just come out right now and say it. So how about we just order some pizza, watch Ratatouille,
Yeah.
come back in the morning and then say guilty and make it seem like a done deal.
I would think that maybe they could blur, obviously maybe not, but blur the jurors' faces out and modulate their voices and let us listen to the deliberation.
I just feel like in this time, anybody could be found out at this point.
Yeah.
And so I felt like, and then the way Maxine Waters was talking about it, I just felt like they had no way out.
Man, if I was on a jury like that, I just put my feet up and be like, nah. And they'd be like, we all want to go home and no one wants their house burned down. I'll be like,
Okay.
I got time.
Yeah.
Not guilty.
Yeah.
I'm sorry. Not guilty does not mean he's innocent of any wrongdoing. It means there's reasonable doubt. You don't have to prove his innocence. You just have to doubt the official story from the state. The state won. It's amazing. The state they scapegoat Chauvin. He's the problem. But I want to mention this one quick thing back to that earlier point. I'm pretty sure it was the prosecution's witness that on cross-examination by the defense was asked, have you ever subdued somebody and held them down until EMS arrived? And he said, yes, I have. It's like, okay, thank you. So the jury can hear that. You also had the use of force expert say Chauvin could have used he could have used more force if he wanted to. He chose not to. And then Nelson, the defense, was like, so Chauvin chose to use a lesser force option instead of just immediately tasing
He could
him.
have tased him, right?
Yeah.
Tased
Yeah.
him unconscious, basically.
Chauvin could have jumped out of a car, walked right up, and just stuck the taser right into Floyd, according to the state's own witness. So it's very, very obvious. There's no fair and impartial jury here. And I'd be really surprised if Cowardly Cahill actually decided to do this. No, the city doesn't care. They're all crooked. They're all corrupt. Thanks for checking out this clip from the Timcast IRL podcast. If you want to see the full show, come back to this channel, youtube.com/TimcastIRL, Monday through Friday at 8 p.m., where you can leave comments and super chat, and we actually will read your comments on the show. Don't forget to like, share, subscribe, and if you want exclusive members-only content, segments you can't get anywhere else, go to timcast.com, become a member, and we even have full bonus episodes. Thanks for hanging out, and we'll see you all next time.